Hello everyone, and thank you for joining us for today's US Laboris client webinar, Sky's the Limit, COVID-19 and the Airline Industry. My name is Annie, and I'm the Business Development Coordinator at US Laboris, and I will be facilitating this session for you today. Our presenters today are all lawyers from the US Laboris firms in the United States, Brazil, Russia, and France. I will then hand over to our first speaker, Ellen Ham from the United States. Go ahead, Ellen, you can start.
Good morning, everyone, to some, and good afternoon to others. Thank you for joining us today. And, all of our 4 countries in the world have been impacted by COVID-19 in very similar ways. The airline industry in particular the passenger airline industry was very hard hit. And we wanted to come together and discuss how our 4 countries have responded to the challenges with a focus on issues dealing with reopening our countries and increasing the flying. And the key issues that we see going forward, including issues of privacy, social distancing, leave from work and return to work issues, and employment claims litigation. So let's get started. If you could go to the next slide, Annie. Thank you. So where are we now? Obviously, COVID-19 is the greatest challenge our 4 countries in the world has really faced in the last 75 years. At the next topic, we're going to ask each of the countries just to give a very brief overview. Could you go back to the, thanks. We're going to ask each of the countries to give just a brief overview on their airline operations and where they are with respect to COVID-19. As many of you know, passenger airlines around the world have either ceased operations or are operating at about 10% of capacity where they were a year ago. The cargo airline industry is faring much better and has suffered a little damage. And obviously aircraft manufacturing has been hit hard. We're going to discuss today what some of our governments from our 4 countries have what steps they've taken to protect human life and to minimize the economic disruption that COVID-19 has presented. And then also, what are some of the challenges and issues we see coming up with restarting our economies? You can go to the next slide. Go ahead, one more. In the United States, we are currently, as of yesterday, at 1.8 million COVID cases. Those are positive cases, and we've had 106,000 deaths. My country, I think, constitutes 1/3 of all cases and deaths in the world. With respect to an overview of the airline industry and its operations, once again, the passenger airlines are operating about 5 to 10% of where they were a year ago, although there is some indication that demand is growing. If you read the news and you're on social media, you'll see that all the US airlines are focusing very heavily on the new clean safety measures they are taking. My government, the federal government, has provided some grants and some loans to airlines that have come with restrictions and certainly controversy. And we predict massive layoffs starting in the 3rd quarter of this year. And once again, the cargo carriers are doing quite well. With respect to the restrictions, with respect to the restrictions on travel abroad, in mid-March, my country began to cut off certain European countries, China and Iran, and they extended that to Brazil in May. But starting around May 26, Americans who come in from those restricted countries, they have to travel through 15 airports. They are subject to enhanced screening upon entry, and they are strongly encouraged to self-quarantine for 14 days. I still travel quite a lot, and we also have additional restrictions. We have 50 states in the District of Columbia in my country, and there are also some restrictions as you travel from state to state. About half of our states have some restrictions. We've also had some restrictions on the military, the movement of military personnel and their families, and that has lessened a little bit going forward, but we're just not quite sure how that will pan out. And now I'd like to have Annie change the slide, and I'm going to turn it over to Bruno from Brazil.
Thank you, Ellen. Good morning, everyone. At least in Brazil and in the US, it's still morning. My name is Bruno Paris, and I am an associate at the Labor and Employment Department of Verano Advogados in Brazil. In Brazil, we have more than 500,000 cases of COVID-19 and more than 30,000 fatalities. The numbers on the slide are from June the 2nd, the day before yesterday, so they are slightly higher as of today. Unfortunately, the numbers are ramping up in Brazil, and in the recent days, we are seeing almost 1,000 fatalities per day. When it comes to the restrictions on travel abroad, in the first moment, the federal government set forth a prohibition on foreign nationals from some countries traveling to Brazil. These countries included China, South Korea, Malaysia, Japan, Australia, and some countries from Europe, such as Switzerland, Norway, and the UK. 1 week after that, however, Brazil expanded the effects of the ban and prohibited foreign nationals from all countries traveling to Brazil, with only a few exceptions that you can see on the slide. The ban is effective at least until June 21st, but it can be extended depending on the circumstances. As to Brazilian citizens, they are not prohibited from leaving Brazil nor from returning from any other country. And also there is no mandatory quarantine from national citizens returning to Brazil, even though the authorities are recommending 14-day period of quarantine if you're coming along from a country, especially from a country that has many cases of COVID-19. Lastly, it is also worth noticing that the Brazilian airlines suspended most of their international flights. With that, I'll turn over to Anastasia.
Thank you, Bruno. Hello, everyone. My name is Anastasia Petrova. I'm a senior associate of Russian member of Youth Laboris Alliance. It's law firm Alrut. Russian authorities have enacted a number of regulations due to COVID-19 situation. And in particular, as other countries, Russia has imposed some temporary travel restrictions. In particular, from March until today, foreign citizens are not allowed to enter Russia with the exceptions of certain countries and with the exceptions of those foreign nationals who have residence permits to stay in Russia and members of official delegations. Also, international flights by Russian airlines are suspended, and according to the biggest Russian airline Aeroflot, they will likely to be suspended at least until the August. However, the Russian Ministry of Transport has already restarted domestic flights from 1st of June. These flights are quite rarely. And at the same time, there is information that Russian ministry plans to restart international flights in July, end of July and beginning of August. One other important thing to consider for foreign nationals who arrived to Russia before situation with COVID-19 is conditions for legal stay in Russia. So we have a condition called migration registration. Actually, each foreign national staying in Russia based on visa or who has visa-free regime, he or she must obtain so-called migration registration when he or she comes to Russia. And at the same time, this migration service is suspended from March 15, and therefore foreign nationals who arrived until March 15 or during this period, they cannot obtain this migration registration or extend registration which has expired during this period. And in this relation, Russian authorities stated that there will be no sanctions for absence of such migration registration, because all this service will be suspended until 15 June. But it is important for foreign nationals staying in Russia to come to migration authorities and obtain or extend their migration registration starting from June 16. So I think this is the most important, and I would like to pass to Camille from France.
Thank you, Anastasia. So I'm Camille Sparfel from Capstan Law Firm, and I'm an associate, and we are specialized in HR law. So I will talk to you about the France restriction regarding travel abroad. So since the 17th of March, there is a strict ban on entry of foreign nationals from all countries, with very few exceptions, for example, cross-border workers or foreign nationals residing in France. The ban is still effective as of today. The Schengen area has closed its borders. As well, the European Union prohibits non-essential trips until the 15th of June at the earliest. Only trips, for example, for compelling personal reason or professional reason could be allowed today. This means that within the Union European trips may be authorized from the 15th of June with no certainty as of today, but international trips may be prohibited for longer. The government, the French government, has indicated that it is in favor of reopening the borders as of the 15th of June without a quarantine measure for European national. So it will, these restrictions have a necessary impact on air traffic. In addition, until the 11th of May, French citizens were not allowed to travel at all. Until the 2th of June, French citizens could not travel more than 1 kilometer. So those restrictions have affected necessarily the air traffic. As of today, it is less than 5% of the usual flight schedule. Only few airports are currently open to commercial transport. For example, in Paris, there is 2 airports and one is completely closed. And it will be open at the end of June. A lot of companies communicate in this reopening. So in the few days, maybe we would have more clarity regarding the reopening and the increase of the air traffic. And now we are going back to Ellen for the next question.
Sorry about that. I have to remember to unmute myself. So when we first began to discuss having a webinar, it was more than a month ago, and one of the things we wanted to talk about were what were the safety measures put in place by the airlines and airline manufacturers for employees and passengers. And since that time, there has been a lot of development in that area. So Annie, if you could go to the next slide, the US slide. I won't read it, it speaks for itself. I think that if you have flown like I have, you will see all of these things in the airports and on board the aircraft. And in my experience, for the most part, passengers are following the mandates or the guidelines to wear masks on board the aircraft. I think one of the things that I wanted to point out that we are seeing with respect to employee safety is in the states, in our different jurisdictions, there are certain limits on the size of gatherings, of meetings, and so obviously that has in some way impacted the training of pilots and flight attendants and other airline employees, so that they are limited to smaller groups in some of these jurisdictions. And so training has become a bit of a challenge. I think in terms of passenger safety, once again, the airlines have been communicating with the public on all that they're doing for passengers. But one of the things that I think has been an issue that you'll probably hear more about is there was, I think, a belief early on that you're stuck in the aircraft and that there's just, it's dangerous. That's not true. I think these aircraft have top of the line filtration systems on board, and our Centers for Disease Control, the CDC in the United States, has even, as of late, been clear to communicate what the filtration systems on board the aircraft, what they do, and the safety of being in that aircraft. And I will turn it over now to Bruno.
Thank you, Ellen. In Brazil, we have 3 major airlines which are operating internally, but at a very reduced rate. It is estimated that the airlines are operating at nearly 10% of where they were before the COVID-19 situation. The cargo carriers are keeping a steady operation, and some companies are even facing a higher demand for cargo freight by air. And in terms of safety measures, in Brazil, passengers must use facial masks in all areas of the airports and inside the aircrafts. The embarkation and disembarkation lines were reorganized so that passengers can keep enough distancing. The companies are also flying with a reduced number of passengers in order to ensure distancing among the passengers on board of the aircraft. And finally, companies are instructing passengers to use hand sanitizers frequently. As to the employees of the airlines, it is important to highlight that in Brazil, employers must ensure a safe and healthy workplace for their employees. This is particularly relevant in these times of COVID-19 because of the increased risk of contamination with the virus. So the employer must adopt safety measures in order to protect the employees. The employer's main duties in that regard are the ones listed on the slide, so you can have a look at them. I would emphasize the employer's duty to provide free of charge protective equipment, which in these times of COVID-19 includes facial masks, wipes, gloves, and hand sanitizers. And also the employers must not only provide this equipment, but also monitor the employees' compliance with all precautionary measures and the regular and correct use of the protective equipment at all times. Other precautionary measures that are being adopted by airlines in Brazil include social distancing in the airports and intensive cleaning of the workplace, including the interior of the aircrafts. Now I'll hand over to Anastasia, who will talk about the safety measures in Russia.
Thank you. In Russia, we mainly have 2 regulatory authorities who have already developed certain regulations, certain detailed guidance for airports, airlines, crews, and passengers. This guidance will be implemented during 3 stages of step-by-step removal of restrictions. Currently, it is not clear what are the time frames for each of the stage. We obviously now are at the first stage, and our authorities will monitor situation around COVID-19 in order to understand whether we can move forward. Can we go to the next slide, please? So actually, safety measures for employees includes the following. It's health monitoring, which implies collecting information regarding certain chronic disease and collecting information about body temperature and collecting information regarding results of COVID-19 and immunity for COVID-19 testing. It is social distancing. It is restricting the number of employees at work to the minimum necessary. So employers must not allow all employees to come back to work if this is not necessary. Employers must provide at their expense employees with masks and gloves, which must be used at the workplace. Employers must ensure that workplace has hand treatment and that disinfection is provided in accordance with the requirements of the authority. Also, with respect to the employees, with respect to the crew, it is required to ensure that cabin crew is placed in such circumstances that other citizens cannot have access to this cabin. And regarding the passengers, the measures are requiring wearing masks at the airport. Passengers must ensure that they have these masks themselves when they are in the airport. However, when passengers are at the onboarding or in the aircraft, it is obligations of the airline to provide these passengers with masks and gloves. And the airline must take into account the duration of flight, and if it's necessary to change the mask each 3 hours, for example, so it must be ensured. Among others are social distancing measures, which requires to ensure that only certain number of passengers can be allowed to the premises, and body temperature checks, which is the obligation of the airport when the passenger comes to the airport, and obligations of the airline at the onboarding. So I would like to pass to Camille, who will speak about the matters in France.
Thank you, Anastasia. So regarding for France, the measures for passengers are obviously to wear a mask, which is compulsory at the airport and on the plane. Otherwise, the passenger could be denied boarding. The airline company must recall the measures of distancing and hygiene in the aircraft and must provide for hand sanitizer. Also, the airline company shall, to the extent possible, ensure that there is physical separation on board each aircraft so that passengers on board are seated next to each other as little as possible. And the airline company distributes and collects traceability documents for passengers to be able to trace the virus, if any. The company at the beginning of the epidemic may require for the passengers to have their temperature taken before entering aircraft. And recently, the government authorized such measure by decree. So I put an example regarding Air France, which is the major airline company in France, but is nowadays authorized by the government. Regarding employees, of course, employees must ensure a safe and healthy workplace. So their main duties are to set up clear and comprehensive rules concerning precaution and concerning the protective measures. The protective measure must be mentioned in the company risk assessment document, and after, of course, consultation with a staff representative. After that, the employer must inform employees of their rules, provide protective equipment to employees free of charge, that's important, face masks, gloves, and sanitizer. Make sure all of protective equipment is appropriate to the risk and in good condition, and monitor employees' compliance with the rules, including the use of protective equipment. The employer can also require to take a temperature of the employees, but not at a general measure. And such a measure has to be very specific and in exceptional reason, and after consultation of the staff's representative. So that was the main safety measures. And now we are going back to Hélène regarding privacy concern.
We have 4 key issues going forward that we're going to cover, and we have a lot to get through, so we'll probably cover them fairly quickly. Once again, you'll have the full PowerPoint, and you can, of course, contact us. The first one is privacy, and when we first decided to hold the webinar, we had 2 primary concerns, I think. One was privacy. We knew that there was probably going to be things in the workplace that we have never seen before, such as taking temperatures. In addition, I think social distancing, which we'll talk about next, was also how is that going to happen, especially in the aircraft. So in my country, we call it the EEOC, which is the Equal Employment Opportunity Commission. They are the government entity or agency that enforces our federal laws prohibiting employment discrimination based on many protected categories. So with respect to temperature checks, you will see, if you fly in my country, sometimes passengers will see airline employees. I've seen it myself at checkpoints having their temperature checked, and that is permissible. With respect to how employers are supposed to treat that information, it is treated, taking a temperature is a medical test, if you will, but employers are permitted to keep a log of that information as long as they don't keep that information or any other medical information related to COVID-19 in their personnel file. They have to have a separate medical file. We also have seen some other measures in the airlines and many companies in the US, such as self-reporting requirements if you are exhibiting any symptoms of COVID-19. Medical questionnaires that go out to employees, and certifications. And certification, I have filled out one myself. You are certifying that you understand what the rules are with respect to PPE and workplace measures to mitigate exposure. Also, disclosure to employees. Obviously, that is a big question, and how that works is if there is an employee that may have come into contact with another employee who has tested positive, you are to discuss with the employee that he or she may have come into contact with someone who tested positive. You are not to disclose the COVID patient's name. But you should tell the employee that they have come into contact, and then based on the circumstances, you will handle it from there. We have not seen yet testing for COVID-19 in the workplace, at least in the airlines. That is a big question if we will see that. I think in the United States, we do not have an overwhelming, consistent level of testing among our 50 states. We've also seen, especially with the flight attendant and the pilots, with their labor unions, is they have been entering into certain agreements that provide flight attendants and pilots, and in some cases, mechanics, additional benefits that they don't have in their collective bargaining agreements. And some of those agreements do provide for employees to self-disclose and to take certain measures. Once again, if you have employees based in the US, the EEOC has guidance for employers related to COVID-19 on its website. It is very useful and helpful information. And of course, if you have any questions, you can contact me, and I'll turn it over to Bruno.
Thank you, Ellen. Well, again, we have to mention the employer's duty to ensure a safe and healthy workplace for all employees, which includes the duty to make sure that the employees are not submitted to a high risk of being contaminated in the workplace. There has been a debate, though, on whether an employee can oppose to a COVID-19 test or to a temperature scan based on his privacy rights. Generally speaking, we believe that employers have the right to submit their employees to a COVID-19 test and to temperature scans, because these are precautionary measures taken to ensure that all employees are protected against the spread of the virus within the workplace. There are certain limitations though. First, the employers cannot test employees who are working from home or on a leave or whose employment relationship is temporarily suspended. So the only employees to be tested are those who are actually going to work and thus sharing their workplace with coworkers and third parties. We believe that generally employees in those circumstances cannot refuse to be tested because the protection of all workforce seems to prevail over a single employee's refusal based on privacy. The second important limitation is that employees can only be tested by an occupational doctor who must guarantee the confidentiality of the results. If the employee is tested and the occupational doctor confirms that he is contaminated, then the doctor informs the company that he is not able to perform his duties and he or she must be forwarded to Social Security. If an employee refuses to be tested, the employer must dismiss him or her for the day without pay and give a warning. A written warning with a clear statement of the reasons is recommended. If the employee's refusal is definitive, then the employer can terminate the employment agreement. This may vary from case to case, but in theory, we believe that if the employee's refusal is unreasonable, unsubstantiated, the employer may dismiss him with cause. Lastly, I just would like to mention that Brazil's General Data Protection Law, which was passed back in 2018, may come into force, or at least some of its terms may come into force in August 2020. So employers' compliance with the law is essential. According to the statute, personal data concerning health is sensitive personal data, and its processing is subject to stricter rules. Now I'll hand over to Anastasia.
Thank you, Bruno. In Russia, there are certain privacy concerns in current circumstances as well. So actually, employees now must collect some new information about health. Employers must collect some new information about employees' health, in particular about certain chronic disease, about pregnancy, about symptoms of possible infections, or about diagnosis. Employees and employers in some regions like Moscow must also test employees for COVID-19 and immunity to COVID-19, so they also can obtain this information. Also, if a person makes tests upon his own decision, and the test is positive, the result will be reported by the doctor to the employer. So in this regard, certain privacy requirements must be ensured. We don't have some specific privacy regulations for this particular COVID-19 situation, so they are general. These requirements are that, first of all, data controller must ensure that there is a proper legal ground for data processing. Of course, for most cases, such legal ground will be justified by Russian Labor Code, which requires that employer must process certain medical information about employees if this processing is required in order to understand whether the employee can perform his or her job duties. But if the purpose goes beyond this, then other legal grounds must be ensured. Individuals must be notified about all types of data processing in local privacy policy. If this is not about employees, but about passengers, or let's say about visitors of the employer's premises, then they shall be notified by some public announcements that can be put on walls or some other place. This notification can also be done online via the website if this is appropriate. Also, it is important that all collected personal data must be deleted in a timely manner. So this is not a type of data which can be processed for longer time than is required in order to achieve certain purpose. For example, to understand whether the employee can perform his or her job duties. So if we collect information about body temperature measurement, we can keep this particular personal data only until until we can understand whether this employee must go home or can be admitted to work at the office. And of course, this data must be kept secure and confidential. And some of our practical recommendations in this regard will be to review existing privacy policies, privacy notices, and consents in order to understand whether they require update and whether they contain new types of data processing. Also in Russia, data controllers must provide information regarding their data processing activities to the local data protection authority. And this information must be exhaustive. So it is obvious that most controllers did not submit all information about health that they collect now, and it is necessary to update these registrations as well. Thank you. I will pass to Camille from France.
Thank you, Anastasia. So there is some privacy concern in France. Of course, the employer's duty to ensure a safe and easy workplace is mandatory, but it cannot breach the employee privacy rights. We have very strict regulation in the European Union and in France. Personal health data is subject to very strict processing rules. And regarding with French law and regarding the European Union regulation of April 2016. Also, the French Data Protection Agency, the CNIL, says in the light of the COVID-19 epidemic, say that employers may not take measures that would breach privacy rights. Therefore, employees may not collect information on potential COVID-19 symptoms by general or automated means or by compulsory means. It can only ask the employees to self-report such information, but it's not mandatory as testing, temperature recording, or employee medical questionnaires. As I said earlier, temperature checking and medical questionnaire can only be offered to employees, but not forced, and necessary prior to the consultation of a staff representative, but it cannot be mandatory, and an employee can refuse to have this test or to fulfill the medical questionnaire. We will see after that what the employer can do. So government has been working, maybe you should have seen on the news, has been working on a contact tracing app named Stop COVID. The use have been authorized both by Parliament and previously by the CNIL, the French Data Protection Agency, at the end of May. It is now available since the 2 of June, but as I said, it is not mandatory, but the Prime Minister encouraged it. So now we will continue with Helen regarding social distancing.
Thank you. The next issue we're going to discuss is social distancing. Go ahead, Annie. US slide. We could probably have an entire webinar on social distancing. In my country, airline employees are considered essential services. And as you know, it is, while in some of the job duties, there may be social distancing that can be obtained, but obviously in the aircraft, that is nearly impossible. So there's obviously a huge focus on the safety and health precautions in the workplace, and especially on the aircraft. We have essentially 3 federal agencies that have been working together to have put out many different guidelines and a lot of guidance on social distancing and measures to be taken in the workplace. OSHA, and that's our Occupational Health and Safety Agency. There is, once again, the Centers for Disease Control and Prevention, the CDC, and then our agency that governs the airlines is the Federal Aviation Administration. And the Federal Aviation Administration, you can search for it online. We have a SAFO, which goes through, some interim occupational health and safety guidance, which was put together by the CDC and the FAA for air carriers, and especially for pilots and flight attendants. And for our crews, meaning our flight attendants and pilots, and the focus is on health monitoring, health protection, and minimizing crew exposure. And they have to have what's called response plans in place for their crews to make sure that if they're identified as being symptomatic or testing positive, is that the airlines get them back where they need to be at their home or housing them in hotels. But we knew the issue of social distancing, especially within the airports and on the aircraft, would be particularly difficult. Airports and airlines have taken a lot of measures to try to ensure that passengers keep a safe distance. There are signs everywhere in the airports. There are markers on the floor to remind you to stay within 6 feet. On board the aircraft, what many airlines have done is block the seating, so they actually reduce the capacity. Not all airlines have done it, but that has been one way. That is not true social distancing. If you don't have someone in the middle seat, you're still within 6 feet of the next passenger. But of course, that's why it's important to wear masks. So also suggestions for returning to the workplace. This would be, not in the aircraft. There are so many things that we're seeing in my country, and I'm sure in others, establishing buffers and evaluating floor plans and creating traffic flow patterns and looking at your ventilation and just so many different things, which you can read there in the last slide. But I will now pass it on to Bruno, Brazil.
Thank you, Ellen. In Brazil, internal and international travel are also deemed to be essential services, and many airline employees are critical to the operation and cannot work remotely. And this whole situation requires focus on safety and health precautions in the workplace, as we have said. Enforcing social distancing is one of the most important precautionary measures in order to fight the spread of COVID. And when it comes to the airports and airlines offices, it is highly important for the companies to reorganize the best they can the workspaces in order to keep workstations apart and make sure that the employees can keep a social distance from colleagues and from passengers at the airport at all times. Other relevant measures to ensure distancing are establishing buffers, evaluating floor plans, creating an elevator usage plan, and putting physical barriers in place. Alternative work shifts and lunch breaks can also be effective solutions. When it comes to the aircrafts, this is much harder to achieve. In Brazil, airlines must comply with regulatory norms concerning the composition of the crew for each kind of flight and aircraft. So companies are bound to these rules when thinking about reducing the number of employees on board. So maybe the most effective way to ensure social distancing inside the aircraft seems to be limiting the number of passengers and effectively distributing them inside the airplane for the operation of the flight. Now I would like to hand over to Anastasia, Russia.
Thank you, Bruno. With respect to social distancing in Russia, we have certain regulations regarding the removal of restrictions. And these regulations, starting from the first stage of restrictions removal, prescribe first that the movement of passengers through the cabin shall be limited, and it is possible only with the exception of visiting the sanitary hygienic block. And therefore, fasten your seatbelt mode will be on during the whole flight. Also, passengers will not be allowed to call cabin crew if this is unnecessary, and passengers' outwear must be packed in a plastic bag and put on a shelf. Getting things from the shelf during the flight will be prohibited. As regards the employees, so there are some general recommendations, and the first general recommendation is to still facilitate self-isolation if it is possible, which means that if still the work is possible remotely from home, so it must be ensured. If not, then a specific distance, which is 1.5 meters shall be ensured between employees, and only a certain number of employees per particular size room can be allowed. And of course, employers shall move to certain regimes of work which will allow not to have all employees at the same time in the office or in some conference room. Thank you. So I will pass to Camille from France.
Thank you, Anastasia. As the other countries, France and the government recommend to take social distancing measure within the offices, the headquarters, and in the aircraft. The government published a document nationwide regarding the measures regarding social distancing. So in airports and offices, there is some rearrangements of spaces to comply with distancing requirements. And also regarding the working time and the schedule, to have staggered work schedules and lunch breaks in order to not have all the employee at the same time in the same space. Obviously, physical barriers and social distancing, general social distancing measures has to be taking place and implemented within the company and within the airport and offices. On the aircraft, there are some, as my colleague says, it's very difficult to take measures regarding social distancing, obviously, to have a limit of seats, but it will be maybe difficult in the few months when the activity will be increased, and we hope of that. So then I put an example regarding EasyJet to modifying the work of the cabin crew in order to be social distant and not to have so much interaction with the passengers and with themselves, the cabin crew. So they agreed with trade union, and it's very important to achieve some agreement with the trade union that cabin crew will not circulate inside the aircraft during boarding, landing, and leaving passengers to take care of their own cabin luggage. And a lot of companies take a policy of no in-flight catering to avoid the interaction between the passengers and the cabin crew. So that was the main measures that I want to highlight to you. So now we are going back to Hélène for the next topic.
Thank you, Camille. The next topic is employee leave and return issues. If you could just change the slide, Annie, to the United States. So obviously the demand within a very short period of time for flying dramatically dropped by about 95%. So many of our airlines, passenger airlines, asked employees to take paid or unpaid leaves. There's also, they asked some of them to take voluntary, what we would call furloughs. And the involuntary furloughs we will see coming up in our third quarter. There's a reason for that based on the grants and the loans provided to many of the carriers. They had to keep employees employed for a certain period of time in order to get the money. And so and most of that money, of course, was used to pay employee wages. We also had what's called the Families First Coronavirus Response Act, or FFCRA, and it only applies to companies with less than 500 employees, and it provided for full-time employees about 80 hours of paid sick time for certain reasons related to COVID, And then that act also provided what we call, or I call e-FEMLA, which was additional type of family medical leave, paid, partially paid, as well. The issue with the FFCRA is, once again, it is limited. It covers companies that have less than 500 employees. Most airlines have more than that, and so most airline employees are not covered under the FFCRA. There are a handful that are, and I think what we're seeing now with respect to the leave issues, one of the biggest concerns we are seeing now is really in the returning to work, and how it interacts with our what we call the Americans with Disabilities Act. That's one of the concerns that we have, is that some employees have obviously been working from home, obviously not pilots or flight attendants, but other airline employees, and now claim they still want to work from home, even though with employees are coming back to the workplace. So that is one of the issues we think. Some employees are saying, I need a reasonable accommodation because of a disability. And so there's a little bit of a struggle there. And I think that's where we'll probably see most of the issues come up with respect to returning from either leave or returning from working from home, is with those that want to continue to stay out on leave, or those that want to continue working from home. And I'll pass it on to Bruno.
Thank you, Ellen. As we are a little short of time, I'll try to be very brief now. The audience can have the PowerPoint presentation and can reach each one of us in case of doubts and questions. So in March, the federal government in Brazil enacted a provisional measure of number 936, which brought some alternatives for employers during the emergency situation. The most important alternatives are the temporary suspension of the employment agreement and the reduction of an employee's salary and working hours. So the suspension we are talking about may take up to 60 days, after which the employee must return to work. And in the case of reduction, we are talking about reducing an employee's salary by 25, 50, or 70%, with a corresponding reduction of the working hours. These may be enforced for a period of up to 90 days. These measures, both the temporary suspension and the reduction of the salary and working hours, may be adopted through a collective bargaining agreement after a negotiation between employer and union, but they may also be adopted through individual agreements in some cases. The Brazilian Labor Code also brings some alternatives for exceptional situations. We listed these 3 alternatives on the slide, and all of them depend on a negotiation with the union and a collective bargaining agreement. One recurrent question that we are receiving now is whether or not an employee who was temporarily suspended or working from home can legitimately refuse to return to his ordinary workplace. The answer is generally no. Unless the employee presents proof that he is sick or unable to perform his duties, he cannot refuse to return to work. Employers have a right to recall workers. And another recurrent question is whether or not the employer can furlough high-risk employees, such as older adults and people with serious chronic medical conditions. We believe that if the employee is not sick and is able to perform his duties, and he's also complying with all precautionary measures, furloughing the employee may create risks to employers. The employee may later claim that he was discriminated against and unfairly prevented from working. Now I'll turn over to Anastasia.
Thank you, Bruno. As we have tight time, I would just like to present certain tips on how to return employees back to work. So it is very important that in certain cases, it will be required to issue an order, which shall be approved by signature of the authorized manager. And in some cases, it even will be required to conclude additional agreement to employment contract with employees on changing back their working regime to office work or to other workplace work. Also, as now employers will have to comply with a number of sanitary and medical requirements, so they have to upgrade their internal policies and provide these policies to each employee for familiarization with the policy, and this familiarization shall be confirmed by the employee's signature in special familiarization list. Also, it is important to appoint personnel who will be responsible for compliance with the new requirements and to organize the work in accordance with new medical and sanitary requirements. It is also important to ensure legal grounds for processing of personal data of employees and update respective policies, consents, and notices. And still, employers must suspend from work high-risk employees, such as such employees who are over 65 years old and who have certain chronic illnesses. It is important that requirements differ in different regions of Russia. So, for example, in Moscow, there are additional measures which shall be taken by employers, which are testing employees for COVID-19 and testing employees for immunity to COVID-19, and particular rules for such testing exist. Thank you. I'll pass to Camille.
Thank you, Anastasia. I will shortly present the ideas of the slides regarding employee leave and return issues. It's the main thing which is important. If the employer has taken all the preventive measures needed to protect employees from COVID-19, and with and after consultation with employee representative, employees may not leave the workplace, the workstation, based on imminent danger. So, although at the other end, the employer cannot follow high-risk employees, and it's very important to reach the occupational health doctor if there is any issues regarding potential high-risk employees or sick employees. And the government communicate very clearly and detailed regarding instructions to deal with an employee presenting symptoms like as self-isolated him or her, and contact his doctor or the occupational health service or the emergency services. So it was the main topics and action to take regarding the employee return in the workplace. So I will pass to Hélène for the.
Okay, the next and the final topic, and we are going to have to run through this quickly because we're running out of time, is the employment claims. What are our 4 countries seeing? And I think, you know, what we expect to see. Can you go ahead and change the slide, Annie? Under our new act, which, by the way, the provisions only go through the end of this year, the actual first case filed in the United States under the FSCRA was filed by an employee of an airline called Eastern Airlines. That is still pending. It was a mother who needed to stay home, claimed she needed to stay home to take care of her child who could not go to school. We are also seeing some wage and hour cases, a lot of it for failure to pay for what we call doning and doffing, you know, putting on protective equipment and taking it off. Also, I think what we might, employers should be mindful is if you're having employees wait considerable time in line to have a temperature check each morning, you might want to look at that issue to make sure they're not spending a lot of time unpaid doing that. We also are seeing claims under, you know, employees have either been let go, furloughed, laid off, and they, due to COVID-19, and they claimed that it was not due to COVID-19, but rather due to some disability such as, that they were let go not due to COVID-19, but some other protected categories such as a disability. So we've been seeing some claims under the ADA for failure to provide reasonable accommodation. We also have seen some other discrimination and retaliation claims. Once again, employees that either have had their hours reduced or have been terminated or laid off, claiming that it was not due to COVID ID, but due to a protected category. And then we actually have seen some fraud claims against employees who falsely claimed to test positive. And of course, the workplace shut down and had to be cleaned and money was lost. So I thought that was interesting. I think we'll also see, we haven't seen them yet, but I think they're going to come up. We call them WARN claims, W-A-R-N. It's an act we have in my country that requires certain notice before you are laid off, either permanently or temporary. And I think that is a claim that we'll probably see coming up in my country. And I'll pass it on to Bruno.
Thank you, Ellen. As we are very short of time, I'll just stick to the most important point of this question here, which in Brazil is that we expect an increasing number of labor lawsuits in the near future due to the higher number of terminated employment agreements. And there are two issues that I would like to draw your attention to that we believe are going to be highly litigated. The first one being the employer's compliance with all requirements set forth by provisional measure number 936 when suspending employees and reducing employees' salaries and working hours. And the second point is occupational diseases, or in other words, employees who were contaminated with COVID-19 claiming to have got the disease in the workplace. So this reinforces the importance of taking all precautionary measures to ensure a safe and healthy workplace in order to avoid liability in the future. In a future dispute where an employee claims to have contracted the virus in the workplace, the proof will be highly circumstantial. So it's very important for employers to have a lot of evidence to show the judge or the court that the employer has taken all precautionary measures in order to convince the judge that the virus may have been contracted otherwise, and therefore that the disease is not an occupational one. Now I would like to hand over to Anastasia.
Thank you, Bruno. Generally, currently we see two types of claims with respect to COVID from employees to employers. First type relates to wage and working hours reduction, and the second type relates to the situation where employer requests employee to come back to work and the employee refuse based on the potential danger to have virus or because of impossibility to leave kids in kindergarten, as kindergartens are still closed in Russia. And now actually we have one real claim of employees of international airport in Russian city Chelyabinsk. So they complained to the regional governor about salary problems and certain inappropriate working conditions due to COVID-19. In particular, their claim related to the situation that they were not provided with the protective clothing. Currently, the claim is being investigated. So we'll see what will happen next. That's only one case that we have now in investigation. Thank you. I'll pass to Camille.
Thank you, Anastasia. So I will focus on the main court decision related to COVID-19 so far, which are concerning the inadequacy of preventive measures implemented by the employer, in addition to a lack of prior consultation with the employee representative. You may have heard about the Amazon case in France. So it's very important, I insisted on this subject and topic, that to implement, to prepare all the steps regarding the return of the employee in the workplace and with the employee representative, and to update the company's mandatory risk assessment document, since we saw a lot of court decision regarding such topic, and the employee representative do not hesitate to go before court to sue the employer and the company to make sure that all the protective measures have been taken with them. So it's very important to have those in mind. And we will see in the future litigation regarding the recognition of occupational disease. I think it will be the next kind of litigation that we have to face. But we need also to be prepared to the increase of labor inspections audits of the company, since the French government help and take a lot of measures to help companies and notably regarding unemployment benefits. So that was the highlight of this slide. And now the presentation is over, and I think Annie will take the conclusion. We'll do the conclusion.
Yes, thank you, Camille. So as we are a bit short on time today, we won't take any questions now, but as previously mentioned, all the presenters will remain available by email for your questions. And if your question is related to a different jurisdiction that was not covered today, you can go to our website, use Laboris website, to the people pages, and from there you can find the right contact. I would also like to mention again that a link to the recording and to the slides will be available on our website as well later today. Then for some more information on the coronavirus, I recommend that you visit again our website, our Corona page. You can download a guide for international employers from there and find information for more than 58 countries. So with that, I would like to thank everyone for attending today and also our presenters for their important insights. I hope to see some of you joining us next week for our next webinar with a different set of speakers who will discuss mobility and immigration issues related to the coronavirus. So yes, thank you all, and goodbye.